arising is the question as to why
Yes.
the EACC has not signed the plea agreement that has been filed in court. Just to give a genesis of this matter, you granted parties leave on application by the counsels for the accused persons to proceed and engage in plea negotiations. We attended various meetings conducting the said negotiations, and the last meeting was held on 28th of August.
Slower. August this year.
Yes, sir. That is last week on Thursday. During the said meeting, several issues arose in that there was an indication that there was a plea agreement that was to be entered into, that was to be signed, sorry. Now, as representatives for the EACC, we requested for the draft plea agreement as the practice has been that once negotiations take place, a draft agreement is shared between the two institutions, the EACC and the ODPP, where we subsequently seek instructions on the draft agreement. Now we requested for the agreement, the draft agreement. But the same was not availed to us. It was actually objected to by the counsels who are there for the accused persons and also the prosecution. We were not able to even gain sight of the said plea agreement to know the contents. And the next time we got to know about the plea agreement is when we came before you, when my colleague came before you on first, when it was indicated that the plea agreement is already on record. Your Honor, in view of the circumstances, we have not been able to peruse the plea agreement. We have not been able to seek instructions on the same. And I believe, Jonah, I have covered the issue that you had raised. But we are still amenable to have the said pre-agreement shared with us so that we can seek instructions on the same.
Come again?
I'm saying we are amenable to having, subject to your directions, having the said agreement given to the ESC so that we can seek instructions on the same. That's all we want.
Very well, thank you. The questions I had have been covered. Thank you. Next is the prosecution, Ms. Nora.
Good morning, John.
Good morning.
I will do a very brief response on the issues raised by ESC. When we first came to this court and informed the court that we had received a request from the accused person's counsel, that what they had requested from us was that we engage in alternative dispute resolution mechanisms with the aim of settling this matter out of court. And I remember.
Slow.
Sorry.
Yes. You can continue.
Yes, that when we came back before you, we informed you that we had agreed to settle the matter via plea bargaining.
By we, you mean?
Yes, the teams, the accused persons and the ESCC, via their communication to the office of the DPP in a letter dated 19th of May 2025.
Well,
The request from the defense, let me just clarify, Your Honor.
Give me time.
Yes.
I wanted to put the we in context.
Yes, that is what I want to clarify. The request was
Yes.
for alternative dispute resolution mechanisms. We have quite a number.
Yes.
So the one that we settled on as a team, that is the defense team, representing the accused persons, and ESCC via their letter to the Director of Public Prosecutions, dated 19th of May 2025, was that they were amenable to the matter being resolved through the bargaining. So we started the process by communicating to the accused persons through their counsel and to EACC, inviting them. First, the meetings were held between ourselves, EACC, and counsel representing the accused persons.
That was on?
We have attached the various attendance sheets, Your Honor. We had a meeting on 22nd of April 2025, 27th of June 2025.
A minute. Come again, fast.
The first meeting was on 22nd of April 2025, Your Honor.
April 2025.
27th of June 2025. 25th of July 2025. The last meeting that was alluded to, where the agreement was discussed, was held on 28th of August 2025. During these meetings, issues to do with the case was discussed, the settlement agreement, the consent order, and the payment.
Oh, slower. It's soft on me.
Sorry, Your Honor.
Today the machine is not running.
Sorry.
So that is why I'm keen to capture each word proceeding through your lips. Were discussed.
Yes.
There are details.
Yes, the details we have attached all that in the clear.
Just come again on that statement.
Yes, the issues to do with this matter were discussed, the genesis of the agreement between EACC and the accused persons in the civil suits. And Your Honor, even during the meetings, we made parties aware. I remember during the last meeting, minutes are available. We informed the team, or rather the teams, that what we had agreed on was what we had indicated in the plea agreement. So we had discussions with all the teams. And on 28th of August, when we had the plea agreement, we requested the team from EACC, we informed them rather of the contents of that plea agreement, and they indicated to us that they had no instructions. You know, this is after 3 meetings.
Slow. You forget quickly.
Sorry.
Watch the pen. That was the rule, the old rule. It works still. Senior counsel can confirm that. They had no instructions.
Yes.
Continue.
You know, we want the court to know that this was after we had discussed with them in our meeting on 27th of July 2025 and informed them that we intended to avail the plea agreement in our next meeting. Our assumption was
Continue.
That because they had been attending all the meetings as scheduled, then what was being discussed in the meetings was then being reported back to the office.
By office, you mean?
I mean, they were coming there as representatives of EACC. We were sitting there as
by
representatives.
office, you mean to
Yes.
EACC?
Yes, yeah. So it was clear, even in our letter inviting them for the meeting on 28th of August, 2025, that the intention was then to sign the plea agreement. Then after they informed us that they had no instructions, and as prescribed by section 137, the prosecution went ahead.
137.
Yes. On plea bargaining, on who should sign the plea agreement. So we went ahead to sign the plea agreement with the accused persons, considering that this was happening on the 28th of August 2025.
Considering, sorry?
That this was happening, this agreement signing took place on the 28th of August, and the matter was scheduled for hearing on 1st of September. So, we did not refuse to hand over any agreement.
Go slow. I'm behind you. We did not
refuse to hand over any agreement. Parties had been attending these meetings. They were aware that that was the day we were going to sign the agreement. I have deliberately left out the issues to do with the settlement in the civil suit. I will leave that to the defense team. So looking at the loan plea bargaining, Your Honor, it is our take that we complied with the law. We have attached copies of attendance sheets. We informed the EACC of the request from the defense. As indicated, they communicated via the letter stating that they were amenable to this matter being resolved through plea bargaining. That is all for now on our part.
Thank you. I will now hear from the accused persons. And of course, I'll begin with the first accused, Mr. Kilokumi.
Institution. The accused person, the office of the DPP, and the trial court. Those are the only recognized parties by the Constitution.
If you can be slow on me.
Yes, I'm sorry. I will watch. I will watch the pen.
And I know you don't come from the rift. I wonder where you're getting that speed. Recognized parties.
And Your Honor, I wish to draw your attention to a provision that is very well known to you. That the office of the DPP, in exercise of its prosecutorial power, is not subject to the directions or control of any other authority or agency. In this particular case, Your Honor, EACC is fundamentally with the constitutional power vested in the DPP. They are trying to exercise control. They are trying to direct.
Slow.
Sorry, Your Honor.
Control. The last there.
Yes, they are trying to control.
Yes,
They are trying to direct the office of the DPP contrary to the Constitution of Kenya. And that cannot be permitted. And Your Honor, we must put things into context. EACC is acting as a complete pretender in these proceedings. EACC, and the charge sheet will confirm, they were the complainants for the case to be instituted, for the criminal case to be instituted. After invoking the criminal justice system, they went to the civil courts. And there they filed suit number 32 of 2018 and suit number E10 of 2021. Your Honor, the claims in the civil suit, the claims in this criminal court are exactly the same. EACC was claiming for 73,474,376.90.
Come again. 73 million.
73,474,376.90. That is what they claimed in the civil suits, and that is what is reflected in the charge sheets. This same EACC entered into negotiations with the accused persons. I personally attended those negotiations. And the starting point of those negotiations were that the criminal case will be withdrawn and the accused persons will make a settlement in the civil courts. And indeed, Your Honor, on the 4th of June 2020, sorry, Your Honor.
Indeed.
Indeed, Your Honor, a settlement agreement
That is
was signed on the 4th of June 2024 and filed in the two civil cases. In that agreement, Your Honor, the accused persons surrendered to EACC immovable properties valued at Kenya shillings 235 million.
Come again.
In those settlement agreements,
figure.
yes, the accused person surrendered properties, immovable properties, worth 235,600,000. Your Honor, you will note that is triple the amount EACC was claiming. And why is it triple? It is triple, Your Honor, because it was assumed if the court were to convict, the accused may be ordered to pay double of the sum that was in question, in accordance with the Anti-Corruption and Economic Crimes Act. And Your Honor, to use street language, EACC were completely sorted. And for them to turn around and try to depict the office of the DPP as if it is doing something wrong is a public relations gimmick of trying to take a higher moral ground without any justification whatsoever. More importantly, Your Honor, we need to ask the legal question whether the EACC is a party to the plea agreement and whether it is required in law to sign that agreement. And the answer is no. EACC was invited to the plea negotiations out of sheer courtesy, out of civility, out of good manners. There was
slower.
sorry, Your Honor.
Pause after every.
I would watch the pen, please.
Out of courtesy,
Yes, civility
civility,
and good manners.
and good manners.
There was no legal obligation whatsoever to have EACC in those negotiations. Next time they should be kicked out. And
I'm
you-
not sure I want to record that one. That one coming from senior counsel is heavy.
That's fine. That's fine, Your Honor.
I'm not
Let
sure.
me justify the statement that I've placed on record.
Zero.
And I am justifying it under section 137A of the Criminal Procedure Code. That section identifies only two parties to a plea agreement. And Your Honor, I want to make it very clear that plea agreements take different shades. This plea agreement is for the charges to be withdrawn under section 87A. Your Honor, with your permission, I will just read what this section says, subject to section
Oh, that is one.
137A.
Thank you. I'm
Yes.
aware of their content.
You're aware of the content. But the point I just want to make is only two parties are identified, the prosecutor and the accused person. And then 1B says the plea agreement could constitute withdrawal of the charges. Your Honor, I also wish to draw your attention to 137B. It identifies two parties, the prosecutor, the director of public prosecutions, and the accused. The complainant does not feature at all. Your Honor, I also draw your attention to 137E, paragraph D. It again identifies only two parties as the parties to the plea agreement. And then, Your Honor, we come to the important aspect where EACC could have a possibility of featuring and does not feature in this case. And that is 137E, subparagraph E. And Your Honor, this one is important. It says the plea agreement be signed by the complainant here is ESCC, if a compensation order contemplated in section 175 2B has been included in the agreement. The agreement is before your honor. It has not included a compensation order under section 175 2B of the Criminal Procedure Code. And for that reason, ESCC has nothing to sign. They are not required to sign any document. They are not required to sign the plea bargain agreement. Your Honor, apart from the Criminal Procedure Code, the substantive, we have the plea bargaining rules, and I wish to draw your attention to rule number 2, which identifies the parties to a plea agreement, and ESCC does not feature. Rule 6 identifies again the parties to that agreement. ESCC does not feature. In the rules, Your Honor, and this is important, Rule 14. Just for context, Your Honor, it's a short rule and an important one for the matter before you. The rule reads, a plea agreement shall be finalized when the prosecutor and the accused person sign the agreement. It's finalized. Being, where applicable, the legal representative shall also sign the plea agreement. In this case, a legal representative is not featuring. We are all dealing with adults, there are no children in this matter. And then the most important one for you, Your Honor, 14 sub rule 3, where the plea agreement includes a compensation clause, the complainant shall sign the compensation clause of the agreement. The plea agreement is before Your Honor, and we challenge the ESCC legal team to show us where there is a compensation clause. There is no compensation clause in the plea agreement. What is contained in the plea agreement is an acknowledgement that the accused persons surrendered properties, immovable properties, valued at 235,600,000.
Sorry?
What is before Your Honor, the plea agreement?
A minute.
Oh, sorry.
You can
Yes. So,
continue.
Your Honor, what is in the plea agreement before you is an acknowledgement that ESCC has received 235,600,000 in surrendered immovable properties and 2 motor vehicles. The plea agreement itself does not have a compensation clause. For these reasons, Your Honor, we urge you to find and hold that EACC has no role to play whatsoever in this plea agreement. We also ask the court to hold and find EACC is not a signatory. There is no requirement for it to sign the plea agreement. That is all I wish to say, Your Honor. Thank you very much for listening to me.
Mr. Ochua.
Your Honor, for purposes of procedure, with your kind permission, we had agreed for purposes of this proceedings.
Sorry?
We had agreed with the counsel for the defense that senior counsel whom will speak first, and then Mr. Sajana will address the court. And then thereafter, the other counsel will get another issue pending. Right. So we kindly request that Mr. Sajana to address you before the other counsel time, if you may permit.
That is in order.
Thank you very much.
Mr. Sagana.
Thank you, Your Honor. Your Honor, for the subsequent accused, we want to adapt fully the submissions very ably made by our senior colleague, Kyogo Filiponi, for the first accused person. And for good usage of time, I do not intend to rehash the submissions, save to add for just 4 key points. Your Honor, in this matter, the complainant is EACC, and it is fully related to the 2 civil matters where EACC is the plaintiff. ADR in the 3 matters commenced between the accused person's hearing,
The 3 means
the 2 civil matters, and this
one.
one. The ADR in the 3 matters commenced between EACC and the accused person's hearing. Without getting into the content, the plea agreement before you has several attachments, including correspondence between my law firm representing all accused persons, and EACC with reference to the 3 matters. The second point is that there was a full settlement by way of restitution and the settlement agreement adopted by the court in the 2 civil matters leading to the forfeiture of the 8 properties valued at 265 million and the 2 motor vehicles. Your Honor, it would be instructive to note that in this matter, a property in Laurentian is the subject and 2 motor vehicles. And the property and those 2 motor vehicles are part of it.
Too fast. Kindly take it slow.